Good evening, this is John Milburn for Laws 12063. This is Advanced Statutory Interpretation and Drafting. We're into week 8 and tonight we're covering what is effectively week 7 material, which is to do with the Acts Interpretation Acts. We have a lot to cover. We have 2 people online. Thank you, Nadine. Thank you, Nicole, for attending online. So the idea of looking at the Acts Interpretation Acts in more detail this week is to emphasise the fact that we are dealing with advanced statutory interpretation. And of course, it wouldn't be appropriate to have a unit on statutory interpretation if we didn't devote some considerable time to the Acts Interpretation Acts, both Commonwealth 1901 and State 1954, that is Queensland. If you're doing this work, this unit from interstate, then please feel free to use your state legislation where you can in assessment work, and I'll try to be flexible. The reason I say that is that I want this primarily to be a useful unit for you rather than necessarily making it easy for me to mark, etc. Speaking of marks, thank you very much for submitting your work in relation to the first assessment, and hopefully by now you've all received your feedback. So in terms of tonight, we'll be looking at the Acts Interpretation Act Queensland primarily, but because I'm not emphasising the Commonwealth, that's not to say it's any less significant or that you shouldn't consider it in as much detail as we're considering the state legislation this evening. In addition to the Acts Interpretation Act, there are other pieces of legislation that are key interpretation acts in Queensland. Now, I could ask if you want to volunteer, but when we only have 2 participants, I don't like to ask specific questions, not too often. So if Nadine or Nicole, you wish to contribute something, please do. So in terms of the other pieces of legislation, we have, so the 4 key pieces of legislation: the Acts Interpretation Act 1954, the Statutory Instruments Act 1992, also from 1992 we have the Reprints Act, and finally, again from 1992, the Legislative Standards Act. So we'll be looking at all 4 pieces of legislation in the Queensland context this evening. So your task is a little broader in terms of your reading, that you need to understand the principles that are laid out in the state and federal pieces of legislation. In the chapter introduction, I indicate that in the Queensland Act, you need to concentrate particularly on parts 3 and 8, which set out the general principles relevant to statutory interpretation. And at the Commonwealth level, part 5, that sets out the general principles as well. There's a number of cases that I'll highlight tonight that you need to consider, and you need to also consider all of this in the context of international obligations and charters. For example, the international charters on human rights. And when you're dealing with statutory interpretation, very soon we'll need to consider the impact of the Human Rights Act in Queensland. And that's a topic that's of particular interest to me because I'm on the subcommittee for human rights at the Bar Association of Queensland. Okay, let's get things started by doing a quick check on how you're going. That is, as a class, not just the 2 that are here this evening, but as a class, how are you going with your participation? This is all to do with assessment number 3. I've shied away from this a bit because I have been keen for you to look at the first assessment in particular, and I do note that the second assessment is not far away. So we're now on the 10th of September, the second assessment is due on the 9th of October, and indeed the third assessment is due at the same time. Please note the cut-off dates are abbreviated in relation to the second and third assessment items. This is really important. With my assessment work, typically it's due on a Thursday evening, 11:45 p.m, and typically with my work, the cut-off is the following Saturday week. So that means you've got 9 days before I stop receiving submissions. Now for assessment item 2 and 3, it's due on the 9th of October, but I'm cutting it off on the 12th of October. So it's much more like an exam type situation, take-home exam situation for 2 and 3. Now, of course, assessment item 3 is, at least for me, very unusual in that it's participation. And you all know the ground rules are to prepare a document or something which can give me a guidance as to the work that you've been undertaking by way of participation. And that should, as a minimum, provide me with information about how you've either attended the live sessions or you've viewed the live sessions at a later time, how you've answered the weekly problems, how you've participated in Q&A, etc. So if you haven't been as lively and as enthusiastic in your participation in this unit as you would probably hope to have been, now is a good time to hit the accelerator and get cracking. So just as a guide, let's have a look at who's been participating in the unit. We'll go to week 6, problem 6, and we see contributions from, well, there you go, Nadine and Nicole. You're the only two online and answering the problem. So I didn't mean to embarrass you there, sorry, but that's Nadine's answer. Thank you very much for that contribution. And Nicole, your contribution there as well. So that's the sort of thing that I want to see from all students, and thank you very much for those contributions. And apologies to all of those, many of you who have, I'm sure, contributed in different ways in different weeks. Okay, so this week we're dealing with information around the Acts Interpretation Acts, and I'd like to start by giving a plug for the Office of the Queensland Parliamentary Council. So this is, of course, part of Queensland legislation, and you'll see the web page has information about the Queensland legislation website. I'd urge you to look at that closely and to follow some of these links that provide valuable information. One that is, I think, very useful is the Queensland Legislation Handbook. So many of these things are very useful. For example, about indicative reprints, private acts, etc. Fundamental legislative principles in relation to the way in which legislation is to underpin democracy based on a rule of law, for example. But one that is very useful is the Queensland Legislation Handbook, and you'll see here the contents, the information, and in particular information about explanatory notes, tabling, disallowance, interpretation, and other material. So certainly that's something that you need to consider. Also, and for those of you that have worked with me in the past, you would have seen that I've referred to this document previously. It's particularly useful in terms of things like information about subordinate legislation in Part 6, which includes the commentary at 611 about explanatory notes, for example. So if you haven't already done so, please take some time to look through that website, follow the links, get a feel for it, and go from there. The other thing that you might need to consider very carefully is your prescribed text. So this is an excellent textbook by Pearson Geddes, and the reading for this week is Chapter 6, which deals with interpretation acts and sections. So that is a very authoritative reference text that you need to consider. I'm not going to walk through the textbook in this evening's session, but I will refer you to primarily legislation and cases. So we now know the 4 key interpretation acts in Queensland: the Acts Interpretation Act, the Statutory Instruments Act, the Reprints Act, and the Legislative Standards Act. Let's start by having a look at the Statutory Instruments Act. I say that because I'm quite sure that you're very familiar with the Acts Interpretation Act. Let's share the screen. I've opted to go through this in Austerley. Remember, of course, that it's not always the authorised report, but I do find it a convenient platform, as many practitioners do. So the Statutory Instruments Act provides for the purpose of the Act at section 2. In essence, it deals with the interpretation and the presentation of statutory instruments. And you'll see there, it applies in section 3 to all statutory instruments. What this Act does is define the type of statutory instruments, set out what can be legislated by a statutory instrument, and it provides as a further object information about rationalising, notification, publication, tabling disallowance requirements for subordinate legislation. So you can see that because there's common terms in this piece of legislation in the Queensland Handbook, that the two work closely with each other. So section 3 provides for the fact that it applies to all statutory instruments. Section 4 is something that you need to consider when you're undertaking a drafting exercise. So given that your second assessment requires you to draft material, you must consider section 4 of this legislation. Section 4 provides that the application of this Act may be displaced, wholly or partly, by a contrary intention appearing in any instrument. So when you're drafting material, you must clearly displace the application of the Act in any instrument if that is your intent. Otherwise, the default provision is that this Act will apply to the instrument that you draft. Now, I keep talking about this instrument. What is an instrument? Well, there it is in section 6. What is the meaning of an instrument? An instrument is any document. And you'll see that in law quite often. In property law, we talk about instruments. You know, it might be a transfer or a mortgage or something else, but it's simply another word for a document. In a way, I wish we would avoid that and actually say document if that's what we mean. But we have the Statutory Instruments Act and we still use that term very often. If we go to the next section, we see the meaning of a statutory instrument, which is an instrument, being a document, that satisfies subsection 2 and 3. And you'll see that subsection 3, that the instrument may be of one of a number of types, a wide range. Typically, they're regulations, but they can be other things, including a statute. So a statutory instrument includes something which is potentially of a wide-reaching consequence. So I'll give you, you'll see, some examples here. And example of paragraph C, an instrument made partly under an express or implied statutory power and partly under royal prerogative. Another example is this, and it's not referred to in the legislation, but you're aware of the QBCC, the Queensland Building Construction Commission. So that organisation has what's called a rectification policy. It's basically a document that provides guidance as to how to regulate and rectify issues to do with building disputes. So it's administered through the QBCC. Now that document, the QBCC rectification policy, is a statutory instrument, and the authority for that proposition is Goldfield Projects against QBCC 2016 QCAT 362. So in QCAT, we deal with a lot of issues to do with QBCC rectification building disputes, or at least we used to. So now let's go back to the legislation, and I'll share the screen for that purpose. If you have any questions as we go, or you wish to provide some comments, please feel free to unmute the microphone. And that means the bonus is I stop talking for a moment, which I'm sure would be useful for everyone. So going back to the Statutory Instruments Act, Section 9 provides for the meaning of subordinate legislation. And subordinate legislation is effectively a statutory rule or a statutory instrument, and primarily they're in the form of regulations, but they can be other things as well. So subordinate legislation, delegated legislation, if you like, is another term for that. So that's what we mean by subordinate legislation. If we go back to the table of provisions, you'll see that Part 4 provides provisions relating to statutory instruments, and it covers sections 14 through to 39A. So let's have a look at 14, which deals with the applicable provisions. So subject to this division, sorry, I clicked the wrong button. 14 is what I intended to click. Subject to the division, a provision of the Acts Interpretation Act mentioned in Schedule 1 applies to a statutory instrument. So if we go to Schedule 1, you'll see reference to the provision of Acts, provision of the Acts Interpretation Act, rather, that applies to statutory instruments. What that means is that when you're reading this legislation, the Acts Interpretation Act will, in some instances, apply not only to Acts of Parliament, but also statutory instruments more generally. Now, the significance of that is this. From a drafting perspective, you need to be aware that if you're drafting regulations or subordinate legislation, that in some instances it will be treated from an interpretation perspective as if it's legislation. And in other words, the Acts Interpretation Act will apply in certain circumstances, in certain ways. Schedule 1 rather, of the Statutory Instruments Act provides for those sections of the Acts Interpretation Act that will have a bearing on the Statutory Instruments Act and statutory instruments generally. If you're practicing in the areas and you're considering an argument based around a regulation or based around statutory instruments, then you need to consider whether the Acts Interpretation Act applies and whether something in that Act can assist you in terms of your arguments. I'll share the screen again. So that's Schedule 1. We'll go back to the table of provisions, and Section 19 of the Act provides that the provisions of the Acts Interpretation Act in some instances do not apply to statutory instruments. So that's referred to in Section 19, and you need to consider Schedule 2 of the Statutory Instruments Act for determining which provisions of the Acts Interpretation Act do not apply to statutory instruments. And you'll see there, Part 1, Sections 10, 13, 15, 15A, etc. So the significance there is that, again, some provisions in the Acts Interpretation Act will apply, others will not apply. Part 4, Division 3 of the Statutory Instruments Act provides for the making of statutory instruments, which deals with things like the commencement, etc., of the legislation. So in that regard, have a look at sections 20 through to probably 39A, noting that there is some repealed sections there. All right. An important one is Section 20, which is the presumption of validity. So all conditions and preliminary steps required for making a statutory instrument are presumed to have been satisfied and performed in the absence of evidence to the contrary. So what that means is that if, for example, a local authority is relying upon a statutory instrument in order to mount a prosecution, for example, then it need not go through the laborious process of proving that the subordinate legislation came into lawful effect. That will be presumed, and it's up to the opponent to argue otherwise and produce evidence to the contrary. So that's a mechanism. I guess when you look at Section 20, it's in some ways an interesting provision, because when you're acting in defence, one of the first tasks always is to consider whether a prosecuting authority has lawful authority to commence the prosecution. If the power is conferred under a statutory instrument, the starting point is that the statutory instrument was validly created. So it removes, if you like, some work potentially, but it also requires you to then find some evidence to suggest the contrary is the case. Let's have a look at a case relevant to this, and I'll again share the screen. The case is Moon against Littleford. So this is Moon against the Gold Coast City Council and Littleford against the Gold Coast City Council, 2009 QPEC 3, which is the Planning and Environment Court reports. So there's the commentary. It was before Her Honour Judge Kingham in the Planning and Environment Court. Judge Kingham is now the President of the Land Court. So these appeals relate to proposal to develop for residential use Miller's Corner and Clark's Corner. These were 2 blocks of land in Currumbin held by the National Trust, the Currumbin Wildlife Sanctuary, basically. So the council, the Gold Coast City Council, granted development approval, and as is objectors' rights to do so, Bruce Moon and Brian Littleford challenged the applications and argued that the development application approval should be set aside because the planning scheme for the City of Gold Coast, under which the applications were assessed, was not a valid scheme. Again, when we consider the Statutory Instruments Act, we're aware that the onus is reversed, isn't it? Council relied on the presumption as outlined in the section to say that all necessary steps and conditions have been complied with in making the delegated statutory instrument. Now, that presumption, of course, may be rebutted, but the applicant needs to produce evidence to the contrary. So what did Bruce Moon, who was a doctor, do? Dr. Moon relied on correspondence between the council and the Chief Executive of the Department of Local Government and Planning as evidence that all necessary steps and conditions were not complied with. Council asserted that it validly complied with the requirements imposed under the then current legislation, the Integrated Planning Act, and the scheme was deemed to be valid. So what did Her Honour do? Judge Kingham referred to Section 20 of the Statutory Instruments Act and noted that all conditions and preliminary steps required for the making of the instrument were presumed to have been satisfied and performed in the absence of evidence to the contrary. And the key part of this decision is at paragraph 48. Sorry for the scanning down. I'm not sure how, I haven't worked out a way of using hyperlinks in OSLE cases. But paragraph 48 said, Her Honour said, I am not satisfied any of the alleged deficiencies referred to by Dr. Moon manifest a failure by the scheme to coordinate and integrate core matters. They are not evidence to the contrary, so as to disturb the statutory presumption that council followed proper process. What that means is that there's a heavy onus on applicants to seek to overcome the statutory presumption. Now let's go back to the Act. No, I've mucked that up completely. I'm on to the next one. So have a look at section 20A of the Statutory Instruments Act, and regulations may be used instead of another type of subordinate legislation, regulations being the most common. Also consider section 50 of the Act, which deals with disallowance. So disallowance says basically that the Legislative Assembly may pass a resolution disallowing subordinate legislation, overruling it if you like, if a notice of disallowance notice is given within 14 sitting days after the legislation is tabled. So there's some basic rules about that. Again, look at the legislation handbook. That provides a good summary of all of these provisions. Have a look at section 51 of the Statutory Instruments Act, dealing with the operation of subordinate legislation that ceases to have effect. So just on that point of disallowance, so the provision sections 50 and 51 of the Statutory Instruments Act are provisions that allow for disallowance of subordinate legislation. The effect of it is, if successful, the subordinate legislation is never taken to have been made, but for the fact that anything done or suffered under subordinate legislation does survive. Otherwise, it has no effect. All right, so the next pillar of statutory interpretation acts, or interpretation acts rather, in Queensland is the Reprints Act. I won't take you to that, but I will invite you to look at the Act for yourself. And what it does, the Reprints Act deals with the obligation on the Office of the Queensland Parliamentary Council to produce reprints in Queensland legislation. And there is the authority to make minor editorial changes. So back in the day, when I started, everything was paper, of course. We didn't have the internet, it didn't exist. So when we talked about a reprint or a consolidation, we were essentially trying to avoid the situation that we all suffered, and that was, you know, a piece of legislation with all these bits and pieces of paper literally glued in, cut out and glued in, representing amendments. So reprints acts were great because it meant that we get to start again before we had to chop up little bits of paper and glue them back in again. You don't know how lucky you are, I can tell you. Don't worry, I used to get that from people like me when I was studying law as well. No questions? All right, I'll just keep talking. If you don't ask questions, I'll keep talking. So at this stage, we'll now move to the Legislative Standards Act, and I'll see if I can get that onto the screen. Again, for your assessment work, you do need to consider the Legislative Standards Act. The idea is that this Act sets out the high standards that Queensland legislation must achieve, and that's incorporated, unsurprisingly, in the purposes of the Act section, which is section 3. I'll share the screen. You should see that now. And the purposes of the Act include ensuring that legislation in Queensland is of the highest standard and is an effective and efficient legislative drafting service. So that's why we have these drafting services available, and it's readily available. So that's the overall purpose. Now, when you're drafting legislation, which you need to do for your second assessment, you will need to be mindful of fundamental legislative principles. Do look at section 4 of the Legislative Standards Act, because that provides the meaning of fundamental legislative principles. These are the principles relating to legislation that underlie a parliamentary democracy based on the rule of law. and it requires legislation to have sufficient regard to the rights and liberties of individuals, the institution of Parliament, and whether legislation has regard to rights and liberties to individuals depends on whether the legislation does or operates in a certain way. So you can see, I hope, that when you're considering drafting your legislation, you need to consider subsection 3, whether legislation has sufficient regard to rights and liberties of individuals, and it depends on some matters. So, for example, B is consistent with the principles of natural justice. So if you are in the process of drafting legislation, and for example, you say that a member of the executive may issue a penalty notice on a member of the public, and that member of the public has no right to challenge the validity or to argue against the notice, then the legislation will suffer the risk of being of an argument that it's unconstitutional, in that when the legislation was prepared, or even the subordinate legislation, it did not have sufficient rights and liberties to individuals, and it was not consistent with the principles of natural justice. A less dramatic example is if the legislation purports to reverse the onus of proof in criminal proceedings. That can only be done with adequate justification. So when you're drafting legislation, it's not just a matter of putting in the legislation whatever it is you want. You need to ensure that it's consistent with the obligations in the Legislative Standards Act. So do have a look at section 4. There is an example, or I can give you an example. There it is, section 7. So under section 7, the function of the Office of the Parliamentary Counsel is to advise on the application of fundamental legislative principles to proposed legislation. So that's part of their job, and they'll follow the legislation handbook as part of the task in undertaking that work. So then have a look at part 4 of the Legislative Standards Act, because it deals particularly with explanatory notes. So sections 22 to 25. Section 22 of the Legislative Standards Act provides that explanatory notes must be tabled with a bill or subordinate legislation for circulation. And you'll see there a reference to the Statutory Instruments Act, section 49, which deals with the requirement to table subordinate legislation. Section 23 of the same Act provides that an explanatory note must include information about the bill in clear and precise language. So in drafting explanatory notes, you must comply with these obligations. The explanatory note must include the bill's short name, a brief statement of policy objectives, a brief statement of the way the policy objectives will be achieved, a brief statement of reasonable alternative ways of achieving the policy objectives, a brief assessment as to administrative cost. You don't need to worry too much about that for your assessment work. Brief assessment of the consistency of the bill with fundamental legislative principles. We now know where to source that information about fundamental legislative principles. A brief statement as to the extent to which consultation was carried out in relation to the bill. A simple explanation as to the purpose and intended operation of each clause of the bill. You may not have too much room in assessment work to comply with all of those things, but that's obviously very important content if you're involved in the process of drafting explanatory notes. explanatory memorandum is what we call them in the Commonwealth sphere. Also look at the next section, section 24, and that provides for the content of the explanatory note for subordinate legislation. And it says failure to comply with this part, so you'll note the 9 matters that are there. In terms of consistent language. I'll just go to the next section, which provides, oh yes, here it is. The failure to comply with this part does not affect the validity of legislation. Let's have a look at a case. Bell against Beatty, our then Premier, and amongst others, Anna Bligh, another ex-Premier, Matt Foley, ex-Attorney General, Terry McEnroth, etc. So basically the Cabinet. So Ian Bell and Trevor Mahaffey took on the 19 respondents who were the members of the Queensland Cabinet at the time. The 12th respondent was the Minister for Primary Industries. So what happened in this case, in Bell and Beatty, was Cabinet decided to submit legislation to Queensland Parliament to prohibit primary producers from sending unpasteurised milk or milk products off their property. Mr. Bell, the first applicant, claimed to be a person aggrieved for the purposes of the Judicial Review Act 1991. He said, "I'm a consumer and I wish to have access to unpasteurised milk because I believe it's beneficial to certain medical conditions from which he suffered." So the issue here in this case was whether the proposed legislation would contravene public policy requirements of the common law and also contravene the Legislative Standards Act. Let's have a look at what Justice Mackenzie said at paragraph 23 in relation to the discussion. Section 4.1 of the Legislative Standards Act states that for the purpose of the Act, fundamental legislative principles are those relating to legislation that underlie a parliamentary democracy based on the rule of law. Section 4.2 states that the principles include requiring that the legislation has sufficient regards to the rights and liberties of individuals and the institution of Parliament. Section 4.3 sets out a number of examples of criteria for determining whether the legislation has done so. While the various criteria are said only to be examples, none, said the court, related directly to the principles expressed by the first applicant. But because they're only examples, the categories are not closed. So there's a message there for would-be drafters. And at paragraph 24, the court said, 2 things may be said about the Act. One is, it's not an entrenched piece of legislation. Legislation inconsistent with it may therefore, as a matter of ordinary principle, be passed by Parliament. And the second is that by reference to section 23(1)(f) of the Act, it clearly implies that Parliament was not prohibited from considering a bill inconsistent with fundamental legislative principles. All they had to do, all that was required of them, was to include a statement in the explanatory note for the bill explaining the reason for the inconsistency with fundamental legislative principles. In other words, if there's a departure, the minister presenting the bill must bring that fact to the notice of the House. All right, so hopefully you can see that that case provides a real-life example of how one might mount an argument based on the statutory provisions against the introduction of certain laws. But from your perspective in assessment work, it shows how you need to be acutely aware of the fundamental rights, the fundamental legislative principles that are set out in the Legislative Standards Act when you're drafting legislation. because if you don't have regard to that, if it were real life, you'd leave yourself open to attack by people suggesting that that hasn't been done. And for the purpose of this unit, if you don't have regard to the Legislative Standards Act, you leave yourself exposed to the risk that I might pick up on that and say that you haven't dealt with that appropriately. Now, I've been remiss in not checking the chat facility. So, thank you, Nadine. A question, a little bit off topic. I've noticed in practice that statutory interpretation is an issue quite a lot in planning and environment matters. And that's true. Do you think that this could be due to the fact that there have been several changes in acts in a short period of time? Yes. Another factor is that I teach environmental law regularly at this university. So I have an interest in environmental law and planning and environment matters. But you're right, we went from the Local Government Act to the Integrated Planning Act to the Sustainable Planning Act to the Planning Act, all in very quick succession. So I think that's a good point. So thank you, Nadine, for that contribution. Now let's have a look at extrinsic material, and you're familiar, of course, with statutory interpretation requiring you to consider extrinsic material. So that's by now second nature. But what legislative basis do we have to consider extrinsic material? We talk about it. We say it's part of the purposive approach to consider the extrinsic material, but what are the statutory provisions? Have a look at the Acts Interpretation Act, but also the Statutory Instruments Act, because both provide for the use of extrinsic information that might assist in the interpretation of legislation. Have a look at 14B of the Acts Interpretation Act. I'm sure you're familiar with that because I've referred to it a number of times, but possibly less likely to be within your contemplation is Section 15 of the Legislative Standards Act, which also provides for the use of extrinsic materials. Now, bear in mind, of course, just a quick off topic, in terms of when legislation comes into effect, you need to consider Section 15A of the Acts Interpretation Act. The effective date is the date of assent, except so far as where the Act provides otherwise. And from a practical perspective, the way you find the date of assent is check Legislation Queensland, which is part of the Queensland Government Office of Parliamentary Council website, and go to the acts as passed in a particular year. If you go to that website, you'll be able to find the information you need. At a Commonwealth level, Section 3A, subsection 2 of the Acts Interpretation Act 1901, the effective date is 28 days after the date of assent. Okay, now let's have a look at the key piece of Queensland legislation to deal with issues around interpretation, and of course that is the Acts Interpretation Act itself. 1954. I'm sure that you're well aware of this, but one of the takeaways from tonight is for you to have a better appreciation of the fact that there are these 4 pieces of interpretation legislation in Queensland. And in particular, you'll note that the Statutory Instruments Act and the Acts Interpretation Act are intertwined. We've already covered that. You'll remember Schedule 1 of the Statutory Instruments Act that provides that certain sections of the Acts Interpretation Act apply to statutory instruments generally. Have a look at Section 2 of the Acts Interpretation Act. And it says, this Act applies to all acts, and then there's the note. For the application of this Act to statutory instruments, see the Statutory Instruments Act, Part 4, Divisions 1 and 2, and we went through those, you'll recall, earlier this evening. Then go to Section 4 of the Act, which provides that the Act may be displaced wholly or partly by a contrary intention appearing in any Act. Probably the most common contrary intention is the date of assent, where it provides that the date of assent will not be as it's stated in the Acts Interpretation Act, it will be this. But whatever it is, if you wish to displace the Acts Interpretation Act in your drafted material, you will need to make that very clear, and you'll need to state the contrary intention in your mock legislation, your draft legislation. Now let's have a look at section 7. You'll see there on the way through, the Act binds the Crown. Section 7 includes any statutory instruments. So in an Act, a reference to a law or a provision includes a reference to the statutory instruments made or in force under that law. An interesting law includes a law of the Commonwealth or another state or territory. Now, Part 3 of the Act deals with the general provisions applying to Acts, sections 9 through to 14D. Have a look at section 9, which provides for the interpretation of an Act in relation to Parliament's legislative power. And you'll see there that it says an Act is to be interpreted as operating A, to the full extent of, but not to exceed, Parliament's legislative power, and B, distributively. Now, distributive is grammatically, it's an adjective. And what it means is referring to each individual of a class, not to the class collectively. So example words, distributive words are each and either. Let's have a look at a case. Let's have a look at Brisbane TV against the CJC and as the respondent. So this is 1996 QCA 295. The Court of Appeal considered that the purpose of Section 91A of the Acts Interpretation Act is to ensure that Queensland legislation is confined within those limits, leaving it to Section 9.3 to preserve the application of the enactment to the extent that it otherwise operates on persons, matters, or circumstances properly within legislative power. So that's Section 9.3. Now go to Section 14 of the Acts Interpretation Act. And of course, I'm just selecting what I believe to be the most important parts. And you see here it's material that is and is not part of an Act. In short, the Act includes everything except footnotes or editor's notes. And you'll see in below subsection 4 examples of a note or examples of a footnote. Very important is a key section, one that I think we talk about in week 1 of statutory interpretation, which is section 14A, interpretation that best achieves the Act's purpose. And do look at the example there, which refers to Partington against the Attorney General. Likewise, early on in statutory interpretation, we talk about section 14B of the Act and the use of extrinsic materials in interpretation. Importantly, it refers to the ordinary meaning, and there's a little bit here of the golden rule about the way in which this is drafted. Subsection B, if the ordinary meaning of a provision leads to a result that is manifestly absurd or is unreasonable, then the interpretation is to provide to be in such a way that avoids such a result. The next section is section 14C, which provides that changes of drafting practice do not affect the meaning, particularly in relation to specific words. And you find that if as a result of the introduction of new legislation, the drafter is attempting to use plain English simple, clear words, there's always a risk that there'll be a change of meaning, either intentionally or interpreted that way, because previously the lengthy, old-fashioned wording was clearly different, more voluminous than the new clear and precise wording. So the idea is that Section 14C provides for a situation where that change of style should not necessarily lead to a result that the material is intended to be different. Now, Part 5 of the Act deals with the issues of commencement of the Act, and we talked about that earlier tonight, 15 to 17. Now, if you look at your textbook, Pearson Geddes at 6.4, it says that all interpretation acts include provisions relating to the date of commencement of acts, and the use of the expression that an act shall come into force or something similar on a particular day is commonly used. So have a look at section 6.4 of your text in that regard. Going back to the legislation, section 15A deals with the date of assent as being the commencement date for the legislation. Section 15B deals with references to time of commencement of acts. So section 15B says, if an act or a provision of an act commences on a day, it commences at the beginning of a day. An interesting little case is Re Flavell, F-L-A-V-E-L-L. It was 1916, SALR 47. What happened is a person died at 8 a.m. on the day on which an Estate Duty Act received assent. The assent occurred at about 10 a.m. So what this section meant was that effectively this person's estate was subject to duty, and effectively the Act had retrospective effect by a few hours. Then go to section 17, which deals with the exercise of powers between enactment and commencement. And if a provision of an Act has an empowering provision, that does not commence on its enactment in certain circumstances. Section 19 deals with repealed and amended acts that are not revived on repeal of repealing and amended acts. So have a look at the example in section 19. And this is, to me, this really shows the importance from a drafting perspective of the use of examples. I always look at them because it just helps to make the Act so much clearer. So example number 1, Act A repeals Act B. Act A is then repealed itself, and the repeal of Act A does not revive Act B. It's nice that it's said in such detail. Then go to section 20 of the Act, which provides for the saving of operation of repealed acts in certain circumstances. I'll leave you to read that for yourself. But what I will say is that section 20 does have the effect of preserving the position as it existed under the repealed Act. A case example of that is Re against HXY, 2017 QSC 108. In this case, the defendants were charged under the now repealed Vicious Lawless Association Disentitlement Act 2013. And there was a pre-trial application. The court had to consider whether section 20 of the Act's Interpretation Act applied to permit proceedings to continue and for a penalty to be imposed as though the repeal had not occurred. And Justice Douglas referred at paragraph 40 and 41 to the law relevant to the matter in the conclusions, saying that Section 22D of the Acts Interpretation Act does preserve the potential liability of the applicant to a penalty incurred in relation to an offence under the Drugs Misuse Act, as well as penalties incurred in relation to an offence provision in the VLAD Act. Now, going back to the Acts Interpretation Act, we have Part 7 that deals with the functions and powers conferred by the Act. Part 8, the terms and references in the Act. Look particularly at sections 32 and 32A in relation to definitions. If an Act defines a word, other parts of speech or grammatical forms of the word have corresponding meanings. Section 32A, definitions are to be read in context. So, definitions in or applicable to an Act apply, except so far as the context or subject matter otherwise indicates or requires. So this section is useful if you wish to argue that the application of a definition would result in the operation of the section under consideration in a way that Parliament did not intend. And the onus of showing the contrary intention, as we discussed earlier tonight, is on the party asserting it. The approach is to assume that the expression used as defined and then ask whether in the particular context it appears that a contrary intention can be shown. In that regard, look at your text at paragraph 6.67 for further commentary. Also consider in the Acts Interpretation Act, section 32AA, a definition in or applying to an Act applies to the entire Act. 32B, which provides for gender. In an Act, words indicating a gender include each other gender. Now the application of this section will always be subject to a contrary intention. An example is the Automobile, Fire and General Insurance Company of Australia against Davies, 1936 54 CLR 534. And the court upheld a decision of an insurance company to draw a distinction based on gender. The rationale was that the insurance company could well have made a different contract, for example, if the husband, not the wife, in that instance, had been involved. But there is a heavy duty of onus. A heavy onus on anyone that asserts that legislation is limited to a particular gender only. Have a look at section 32C, which provides for number. So there's a presumption which can be rebutted. For example, in Blue Metal Industries against Dilly, 1969 117, the context of legislation dealt with takeovers, and the court rejected the claim that the singular as one company included the plural as a group of companies. All right, well, we've probably reached the stage where you're well and truly tired of listening to my voice. Thank you for your patience. We have more material to cover in relation to this week. I appreciate I'm getting a bit behind, but we will catch up. Now, we'll sign off soon. Before I do, Nadine, Nicole, any questions, or are we all good? We're right to go? Okay, thank you very much. Okay, well, thank you for your attendance. For those of you watching as a recorded session, please consider joining us live. If we have more than two, it's a bit easier to have some discussions, which means less of me talking. All the best, and we'll see you next week. Bye for now.